Directors. So first the meaning of directors. Okay, a company is an artificial person. Okay, a company is an artificial person. Company is not a natural person. It is invisible and it is intangible. Okay, it is invisible, we cannot see it, and it is intangible, we cannot touch it. So it carries its business through some living person or persons. Okay, so the company carries its business, do its activity through living persons. Okay, these persons are called directors. Okay, who do the activities of the company. These such persons are called directors. Directors direct the activities of the company. Okay, they direct the activities of the company. They give the direction to the activities of the company. So this was the meaning of directors. The definition given in Companies Act in section 2 clause 34 is any person appointed to the board of the company is known as director. Okay, any person who has been appointed to the board, that person is called director. This is the definition given in Companies Act. Every company should have directors. Okay, it is compulsory that every company should have the director. What does section 149 says? It says minimum number of directors in a public company should be 3, in a private company it should be 2, and in a one person company it should be 1. Okay, the maximum number of directors, it is 15. Okay, a company can appoint more than 15 directors after passing a special resolution. Now see how first directors are appointed. Okay, first directors appointed. The first directors are appointed by the subscribers of memorandum. Okay, the subscriber of the memorandum, they appoint the first directors. If they do not appoint, okay, if the subscriber do not appoint the first directors, they themselves become the director till the first AGM, first annual general meeting. Okay, if the subscriber do not appoint the first directors, they will themselves become the directors. Okay, they are the directors till the happening of first annual general meeting. Okay, and in this meeting subsequent directors are appointed. Okay, the first directors who were appointed, they retire in the first general meeting. Okay, and they can be reappointed. Okay, if the company wants, they can reappoint those first directors. Section 152 clause 2 said every director shall be appointed in general meeting. Okay, the appointment of directors can happen only in general meetings. So this was the appointment of directors. Now see the powers of the directors. The powers of the directors are set out in articles. They are written in the articles. The board of directors acts within the scope of powers given to it. Okay, the board of directors, it will act within the scope of powers given to it. This is the scope of powers given to the board of directors. They will act within it. Okay, they cannot act outside it. Once delegated and vested in board, shareholder cannot control how board use them, but within scope. Once the powers are delegated and vested in the board, once the powers are given to the board, then the shareholder cannot control how the board will use these powers. Okay, but the only limitation is that the board can use them within the scope. Okay, within the scope. Okay, what are some general powers, common powers given to the board? Section 179 says that a board can do anything which the company can do. The board can do anything which a company can do, but there are two restrictions. It cannot do anything which the company itself cannot do under its memorandum. Okay, if there is something prohibited under memorandum, the company cannot do it, so the board can also not do it. Any such act done is ultra vires and void. If they do such act, okay, which the company cannot do, that act is ultra vires. That ultra vires means beyond power, and that act is void, it is useless. It does not have any value, it is valueless. Acting within powers of company. Okay, the board has to act within the powers of the company. Powers of board limited to extent company delegated them through articles. Okay, the company delegated the powers to the board through the articles. Okay, the board can use these powers within that extent only. Okay, the company will define the extent of the powers of the board through the articles. If acts beyond powers but intrawires the company. Okay, if the board is acting beyond the powers given to it, but that act is intrawires the company, not ultrawires. Intrawires is means that act is within the powers of the company, although the act is outside the power of the board, but it is within the power of the company. In that case, the company may ratify the act, the company may approve it, okay, make it valid in general meeting. If the company do not ratify it, the directors will be personally liable for breach of authority, okay. So these were some general powers, common powers. Now see the specific powers. Section 179 clause 3 says the affairs of company, their direction, control and superintendence. The directors or the board of directors, they direct the affairs of the company, the activities of the company, they control the activities or the affairs of the company, they have superintendence over the affairs of the company or the activities of the company, they supervise the activities of the company, the affairs of the company. This is the work of directors. To increase subscribed capital, dispose of shares available for issue. If there are any shares available for issue, then they will dispose of them, they will issue them. This will increase the subscribed capital. To appoint first auditor within 1 month of registration. Within 1 month of registration, the directors have the power to appoint the first auditor and to fill the vacancy in the office of the auditor. To appoint additional directors if that they are authorized, okay, if they are authorized to appoint, they can appoint the additional directors and fill vacancy in the office of the directors. And if they are authorized, they can appoint alternate directors, they have the power to appoint alternate directors and to contribute such amount as it think fits to national defense fund, okay. These were some specific powers. What are the powers which are to be exercised only at the board meeting, okay. These powers can be exercised only at the board meeting. What are these? Power to make call on shareholders in respect of money unpaid on their shares, okay. If shares are issued, some amount has been paid but some amount has been remaining unpaid, it has not been paid, okay, the payment is pending. In that case, the power to call these shareholders to make the payment of the unpaid amount, that power can be exercised only at the board meeting, okay. That call can be made only at the board meeting. And what else can be exercised only at board meeting? Power to issue debentures, power to borrow money, power to invest fund of the company, power to make loans. All these powers can be exercised only at the board meeting. What are the powers which are to be exercised by board unanimously, okay, in which the board has to be unanimous, there should not be any dissenting voice, everyone should agree, everyone accepts the decision. What are these powers? If person is already a managing director or manager of another company, to appoint him as managing director or manager in own company. Suppose there is some person who is the managing director or manager of some another company, and this company wants to appoint him as its own managing director or manager, then this decision should be taken at the board meeting and the decision should be unanimous, okay. Everyone should have agreed to this decision. Or what is the another decision which has to be taken unanimously, okay, it is to invest in shares or debentures of another company. This decision is should also be unanimous, one should accept and agree to this decision, then only this decision can be taken. So these were powers. Now what are the duties of directors? The directors are accountable for their acts done on behalf of the company, okay. They are accountable for their acts which they do on the behalf of a company. They should ensure strict compliance of provisions of the act, of the company's act, okay. They should ensure that the provisions of the company's act are complied strictly. To perform functions with reasonable care and attention, they are not liable for bona fide error of judgment. They should perform their functions with reasonable care and with attention, okay. But if they are making any judgment bona fide means honestly, okay, and if there is any error in their judgment, then in that condition they will not be liable, okay. They are safe. To individual members, director owe duty to their company, not individual members, when doing transactions with such members. They are not trustees of individual shareholders, okay. The director owes duty only to the company, not to the individual member. They are the trustees of the company, not of individual members, okay. They are not the personal trustees of the individual members, they are the trustees of the company, they owe duty to the company. To disclose personal interest, it is their duty to ensure that the personal interests do not clash with the interest of the company. Okay. And what is next duty? To attend board's meeting, though they are not bound to attend all meetings, but if absent from 3 consecutive meetings in the last 12 months, then the office of the director which shall stand vacated. Okay. If he is absent from 3 consecutive meetings in the last 12 months, then his office will be stand vacated, he will be removed. Not liable for decision taken in board meeting in which he is absent. Suppose he is absent in any board meeting, and if any decision is taken in that meeting, then he will not be liable for that decision. Towards third persons, if the directors enter into contract with third person in his own name, suppressing that he is doing so in his capacity as a director, he will be personally liable for loss to company due to that contract. Okay, suppose the director is doing any contract with any third person in his own name, but he is suppressing the fact that he is doing this in the capacity as a director. In this case, if the company is having any loss due to that contract, then that director will be personally liable for that loss. Not liable for contracts entered by third company with the by third party with the company is liable. If the third party is doing the contract with the company, in that case the company is liable, the director is not liable. If guilty of fraud, deceit, or or commit tort in relation to company's transaction, he will be personally liable to pay compensation to person. Okay, if he is guilty of any fraud, deceit, or commit any tort in relation to company's transaction, he will be personally liable to compensate the person who is having that loss. What is the next duty of director? To prepare director's responsibility statement and to send to registrar along with the board report. Okay, the director has to prepare the responsibility statement, and along with this statement he has to send board's report to the registrar. What are in these statement and reports? It is said that the director is saying that I have followed applicable accounting standards. Okay, applicable accounting standards have been followed, and has taken sufficient care for maintenance of accounting records. Okay, sufficient care has been taken for maintaining the accounting records to safeguard the assets of the company and to prevent, detect fraud and other irregularities. So these were the duties of director. Now see the removal process. What are the reasons and the ways a director can be removed? So the reasons: a director can be removed if he incur any of disqualification is specified under Companies Act. Okay, if there is any condition in which a person is disqualified under Companies Act and the director is in that situation, then he will be disqualified. Or if he is absent from 3 consecutive board meetings over the last 12 months. Okay, if he is absent for 3 consecutive board meetings, he will be removed. Enter into contract or agreement against provisions of section 184. If he is making any contract or agreement which is against the provisions or rules of section 184, then he will be removed. If he is disqualified by order of court or tribunal, in that case, in that condition also, he will be removed. Or he is convicted by court for any offense in which he is sentenced to imprisonment not less than 6 months, in that condition also he will be removed. Or if he do not abide by terms and protocols mentioned in Companies Act, in that condition he will be removed. Or he resigned voluntarily. Okay, he himself resigns. And what are the ways he will be removed? the, these were the reasons. And what are the ways? He can be removed by resignation, he gives resignation. Or if he is absent from 3 consecutive board meetings from last 12 months, this office shall stay vacated. Okay, he will be removed. Or he can be removed by shareholders by passing ordinary resolution after giving him reasonable opportunity to be heard. Okay, the shareholders can remove him by passing ordinary resolution, but a reasonable opportunity should be given to, okay, for him to be heard. He can present his case. Given director is not appointed by central government or tribunal, a director cannot be removed through in these ways. If that director is appointed by the central government or tribunal, the shareholders cannot remove him like this. So this was director. meaning, definition, powers, duties, etc. Removal. If you want the PDF for revision of these notes, you can get the PDF link, download link in the description box or the comment box. If you are interested, you can take it from there. Next will be meeting. We will cover it in next video.